Hey everybody, welcome to Module 8, Crime, Media, and Movements. This is part 2, and we're going to talk about 3 different areas that we've seen movements and media and the impact they have on each other. So let's get started. The 3 areas we'll be talking about in today's lecture have to do with court, corrections, and policing. Today's lecture will focus mostly on court, and then following lectures will focus on corrections and policing. So first, when we talk about media movements and courts, it's important to remember that media fills an important role in that it ensures that government is accountable to the public. Now, we've talked about this in past lectures where we say, really freedom of the press and freedom of speech and right to a speedy trial, right to a jury of your peers, right to face your accuser, all of these rights get balanced in one way or another with good intentions in mind, ensuring that due diligence is used in both the public interest as well as the interest and rights of the defendant. And really, media is that mirror to show what's really going on. Media can also set the national agenda through coverage decisions, thus influencing public perception of the importance of political issues. So it also is a magnifying glass and, in a way, if you will, a spotlight to say, hey, this is worth paying attention to. Finally, understanding how media choose which issues to cover is important for understanding development of government priorities and policy decisions. So it kind of is that spotlight we cannot ignore. So certainly this would have something to do with movements. We're going to go back through some basic principles of news media and coverage and pull it back together into courts and focus on the Supreme Court as well. So remember, media coverage depends on news values. And a lot of these news values are pretty common across the research journals when you look at them. So we talk about things like impact, proximity, timeliness, prominence, conflict, currency, and frankly, the bizarre or unusual. So these are the kinds of things that hold public interest and make a story essentially newsworthy. Also, these media values don't necessarily lead to absolute coverage of the most legally significant cases. Rather, the reliance on cues that journalists use when they start their coverage can result in less legally important cases actually being brought to the public consciousness. And therefore, other cases with great potential long-term importance can go uncovered by the media. So this is to say these cues really are not the end-all be-all of coverage, but at the same time, they do tend to guide and lead us into what stories we should be paying attention to. But we need to recognize that there can be bias brought in by the dependence on these values, and we can miss some cases that really are important. So essentially, how do journalists assess the importance of Supreme Court decisions? Because one could argue that the coverage on the highest court in the land would certainly impact movements in the criminal justice system. So if a journalist is going to go do coverage on the Supreme Court, how does that work exactly? Well, first we have to talk about the courts generally. So legislative and executive branches of American government are often characterized by their true publicity-seeking behavior. They like to make headlines, and they seek to, but you have to recognize that this is not necessarily true of the judicial branch. They are much more quiet and introverted in their persona. However, the importance of media coverage is actually quite magnified for the U.S. Supreme Court, because lacking these public affairs mechanisms that you're going to see in the legislative and executive branches with big press conferences and so forth, and spotlight interviews of celebrity politicians, the court is very dependent on media dissemination of information about its decisions. So the justices largely stay out of the spotlight, the 9 justices. So we have to think about how media and the justices kind of work together. So whether or not a court decision is actually covered is highly dependent on the newsworthiness of the decision and the legal salience meaning that it's legally significant upon cases over time. It has a lot of breadth. We'll get more into this in a moment. So having power of neither the purse nor the sword, meaning the legislative or the executive branch of enforcement or collection, enactment, or finance, the court really lacks overt mechanisms to ensure compliance. So its ability to influence policy or movements or make changes in society really depends on a general willingness to abide by its decisions and the public's willingness to exert pressure on other actors to comply. So that's kind of the only mechanism available to the Supreme Court. And here's the other problem. Because public knowledge about the court is so low, the court depends on media to build support and influence policy. So when you think about it, if you were to go out on the street and ask the everyday person walking outside, can you name all 9 Supreme Court justices? I think the vast majority of the public would really struggle to do so. In a way, that's good because the justices are out of the media spotlight, but in a way, it's not so good because we should know the names of people that have one of the highest influences on our lives. So it's kind of funny how that tension works. No single individual speaks for the court, with the exception of the Chief Justice, right? And thus, journalists actually do not have the kind of sources that they would have with other political institutions, right? The justices don't necessarily have handlers, they have clerks, and they don't take interviews, and they are not really collaborative or cooperative with the press very often. Additionally, the Supreme Court's decision-making processes are not open to reporters. It is a closed court, and thus justices really tend to avoid the press, expressing themselves really only through published opinions and public documents. So again, the awareness of the court is low almost by design. Journalists will rely on cues surrounding a case to navigate opinions and determine whether a case merits any coverage. And this includes coverage that impacts social movements, reforms, and all kinds of things that impact the criminal justice system. Research has determined that First Amendment cases, civil rights, and criminal cases are more likely to receive media coverage. So these are the ones that get the most spotlight. Another indicator is the number of amicus briefs filed. And some of you might go, what's an amicus brief? So we'll do a quick overview of amicus briefs in a moment. So the basic function of an amicus brief, or we call them amicus curiae, or friend of the court, amicus meaning amiable. These briefs are filed by someone who has a strong interest in the subject matter of a lawsuit, but who is not actually a party to the lawsuit or directly involved with the litigation. So it's kind of someone that's saying, I have a strong interest in this because it impacts my life, my well-being, or my business. They really address all kinds of things like policy issues. They provide a more sympathetic advocate and a little bit of a reality check on what's going on outside of just the parties involved. They can supplement or bolster a party's brief. They can provide a historical perspective or technical assistance in really seeing the impact of the case. They can endorse a party. They can seek or to mitigate or expand the effects of a potentially important prior court opinion, depending on whether or not the opinion is damaging or helpful. So in essence, an amicus brief can kind of serve in the function of a paralegal or a legal secretary providing a lot of extra information that might need to be considered as a case moves forward. So they do a lot of research and history and background fact-finding as these cases unfold with the Supreme Court. And essentially, these amicus briefs are really aimed at protecting the interests of individuals or organizations who are absent from the proceedings, but whose interests are potentially jeopardized by the litigation. So it kind of gives that outside perspective that often is very needed. So if there is a case that has a lot of filings of amicus briefs, that's an indicator to a journalist that this is a very important case, or it's high profile, or it has a high impact factor. When we look at not just the Supreme Court, but also as it impacts media movements, Supreme Court decisions really can be very central to a media movement's survival and success. So we get to the point where we say, is court activity going to help or harm my cause? And this is a burning question for social movements and scholars siding with them. It could do either, and it's sometimes difficult to get at the answer to this question. So fears are not only that court involvement or activity may be an ineffective waste of time and a waste of resources, but there also is a fear that it may be counterproductive, that court-centered activism will legitimize the system and circumscribe the struggle in which ways or in ways that prevent radical challenges to the status quo, that it's going to do what we call norm affirmation and actually change and de-radicalize the movement itself. So that's how it can be counterproductive. That such a big spotlight is shown upon it that people start to see it in a different way and it does more damaging things. And of course, all of this is wrapped up within a political opportunity structure. So if you've studied things like rational choice theory or kind of game theory, we often calculate our risks and benefits within a set of rules and chances of those risks or benefits playing out. Again, trying to maximize our own position or advantage. So essentially, we're going to be doing the chances of winning through political mobilization, including social mobilization and media campaigns, and we're going to weigh it out against the chances of losing or the social movement being completely dismissed. So this depends on the responsiveness of the political elite. And when we talk about political elite, we're talking about support from power players and power brokers, and generally, and with respect to the issues involved. So if you can get an endorsement or support from some of these political elites, that is a good sign that your movement is going to have momentum and longevity. And also whether the resources available to the social movement and its allies are sufficient to make headway by creating political pressure to act. Finally, we'll get into what we call court-centered activism. So if you're going to do a social movement and you seek large changes to the criminal justice system, we again talk about the opportunity cost. So social movements pursue court-centered activism where they challenge decisions or they use lawsuits to try to make changes and force someone's hand, when this on balance and given their opportunity situation is perceived as the best option, or at least at minimum a complementary strategy to further the cause. So these are the three things that they consider. It includes what we call barriers. This is lack of rights awareness, the nature of the law, thresholds of access to the court, rules of standing, procedural requirements, costs, time, and the need for legal expertise. These can all keep someone from actually seeking court-centered activism. And certainly we have to consider resources. Do we have organizational and financial resources and legal support structures to pursue a case in court, including intellectual, political, and financial support from transnational activist networks? So we don't want to be kind of a one-trick pony that is existing in a vacuum. We will be dismissed, the case will be thrown out, and that movement will be dead on arrival. The last part is potential gain. So this is the prospects for succeeding if we have a reasonable chance of winning the case and advancing the cause based on previous experience and perceptions of judicial independence and effectiveness. And so this is when you kind of do an evaluation of judges that will be key players in decision making and whether or not they are sympathetic to your cause or see merit in your cause, and whether or not that can sway that decision-making process. So essentially, this is just a quick way to think about courts and media movements as they come together. Again, largely with a focus on the Supreme Court, as well as court-centered activism, and the ways that journalists need to consider which cases and which movements merit the most coverage. So I hope you found this helpful, and we'll see you in the next lecture.